A mercenary, sometimes known as a soldier of fortune, is an individual, particularly a soldier, who takes part in military conflict for personal profit, is otherwise an outsider to the conflict, and is not a member of any other official military. Mercenaries fight for money or other forms of payment rather than for political interests. Beginning in the 20th century, mercenaries have increasingly come to be seen as less entitled to protections by rules of war than non-mercenaries. The Geneva Conventions declare that mercenaries are not recognized as legitimate combatants and do not have to be granted the same legal protections as captured service personnel of a regular army. In practice, whether or not a person is a mercenary may be a matter of degree, as financial and political interests may overlap. Protocol Additional GC 1977 is a 1977 amendment protocol to the Geneva Conventions. Article 47 of the protocol provides the most widely accepted international definition of a mercenary. Though not endorsed by some countries, including the United States, the protocol additional to the Geneva Conventions of 12 August 1949, and relating to the protection of victims of international armed conflicts, the 8th of June 1977 states, Art. 47. Mercenaries. All the criteria must be met, according to the Geneva Convention, for a combatant to be described as a mercenary. According to the GC3, a captured soldier must be treated as a lawful combatant and, therefore, as a protected person with prisoner of war status until facing a competent tribunal. That tribunal, using criteria in APGC 77 or some equivalent domestic law, may decide that the soldier is a mercenary. At that juncture, the mercenary soldier becomes an unlawful combatant but still must be treated with humanity and, in case of trial, shall not be deprived of the rights of fair and regular trial, being still covered by GCIV Art. 5. The only possible exception to GCIV Art. 5 is when he is a national of the authority imprisoning him, in which case he would not be a mercenary soldier as defined in APGC 77 Art. 47, d. If, after a regular trial, a captured soldier is found to be a mercenary, then he can expect treatment as a common criminal and may face execution. As mercenary soldiers may not qualify as POWs, they cannot expect repatriation at war's end. The best-known post-World War II example of this was on the 28th of June 1976 when, at the end of the Luanda trial, an Angolan court sentenced 3 Britons and an American to death and 9 other mercenaries to prison terms ranging from 16 to 30 years. The 4 mercenaries sentenced to death were shot by a firing squad on 10 July 1976. The legal status of civilian contractors depends upon the nature of their work and their nationalities with respect to that of the combatants. If they have not, in fact, taken a direct part in the hostilities, they are not mercenaries but civilians who have non-combat support roles and are entitled to protection under the Third Geneva Convention. On 4 December 1989, the United Nations passed Resolution 4434, the International Convention Against the Recruitment, Use, Financing and Training of Mercenaries. It entered into force on 20 October 2001 and is usually known as the UN Mercenary Convention. Article 1 contains the definition of a mercenary. Article 1.1 is similar to Article 47 of Protocol I. However, Article 1.2 broadens the definition to include a non-national recruited to overthrow a government or otherwise undermining the constitutional order of a state, or undermine the territorial integrity of a state, and is motivated to take part therein essentially by the desire for significant private gain and is prompted by the promise or payment of material compensation. Under Article 1.2, a person does not have to take a direct part in the hostilities in a planned coup d'etat to be a mercenary. Critics have argued that the Convention and APGC 77 Art. 47 are designed to cover the activities of mercenaries in post-colonial Africa and do not address adequately the use of private military companies by sovereign states, the situation during the Iraq War and the continuing occupation of Iraq after the United Nations Security Council sanctioned handover of power to the Iraqi government shows the difficulty of defining a mercenary soldier. While the United States governed Iraq, no U.S. citizen working as an armed guard could be classified as a mercenary because he was a national of a party to the conflict, and they are involved with a firefight in the continuing conflict. They are mercenary soldiers. However, those who acknowledge the United States and other coalition forces as continuing parties to the conflict might insist that U.S. armed guards cannot be called mercenaries. The laws of some countries forbid their citizens to fight in foreign wars unless they are under the control of their own national armed forces. If a person is proven to have worked as a mercenary for any other country while our